Good morning, I'm DeWaal, and this is Bridging the Week for September 23rd to 27th, and today is September 30th, 2019. There were lots of significant regulatory and legal developments in the financial services industry last week. Let's cover a few. In one matter, Omcat LLC agreed to settle charges brought by the Commodity Futures Trading Commission that it violated speculative position limits in two soybean products futures contracts traded on the Chicago Board of Trade on two occasions, one in 2016 and the other in 2018. However, one of those occasions was already subject to an enforcement action brought and settled by the CBOT against the trader for Omcat in June 2017. CBOT also brought and settled a second disciplinary action against the same trader for the 2018 incident contemporaneously with the CFTC matter. According to the CFTC, Omcat violated the spot limit for December 2016 soybean oil futures by 360 contracts, beginning the first day the relevant spot month limits went into effect at the close of business on November 29, 2016, and for August 2018 soybean meal futures by 155 contracts on the second day the applicable spot month limits were in effect on July 31st, 2018. On each occasion, Omcat liquidated its volatile positions the next trading day. The firm resolved the CFTC's charges by agreeing to pay a fine of $140,000 US. Although speculative position limits are an important device under applicable law to help ensure competitive markets, the parallel actions by the CFTC and CBOT involving Omcat and the trader appear to be discrete incidents that were quickly addressed. It is not clear how the public interest is served by the CFTC employing scarce resources to bring and resolve a Me Too enforcement action. I've got more details on this matter on the article version of Bridging the Week at www.bridgingtheweek.com. Check it out. TMC Bonds LLC resolved charges with the Securities and Exchange Commission that from at least January 2016 through June 2018, it held itself out as an anonymous trading platform for certain taxable and non-taxable fixed income securities when it was disclosing the identities of certain subscribers to other subscribers without their consent. TMC is a registered broker-dealer and operates as an alternative trading system. The firm was acquired by the Intercontinental Exchange as of July 23, 2018. The SEC claimed that during the relevant time, TMC's marketing and operating procedures generally noted that its subscribers' identities would remain confidential. However, alleged the SEC, on approximately 2,600 occasions, TMC employees disclosed identities of certain firms attempting to trade on the firm's platform. The SEC charged that TMC failed to notify its subscribers that its platform was not totally anonymous and failed to amend filings with it to correct prior disclosure that its ATS was anonymous. The SEC also claimed that TMC's written supervisory procedures only address anonymity and subscriber confidentiality in general terms, and the firm's training on the matter was also deficient. TMC agreed to pay a fine of $2.1 million to resolve the SEC's enforcement action. And finally, a federal court of appeals stayed all district court activity related to a claim by Kraft Foods Group Inc. and Mondelez Global LLC that the Commodity Futures Trading Commission violated a mutual gag order included in a settlement of an enforcement action by the CFTC against the two food giants. Additionally, the appeals court ordered that all papers filed before it be made public as of October 1st, absent an express statute or quote-unquote recognized privilege that requires confidentiality. The appeals court also ordered the defendants to file a response by October 7 to a petition for mandamus filed by the CFTC on September 13 and invited the judge in the district court action, the Honorable John Blakey, to provide his own response to the CFTC's petition, quote, if he so chooses, end of quote. By the way, a party may seek a written mandamus to compel a government agency or court to correct alleged prior unlawful conduct. In response, the district court canceled all pending deadlines and hearings, including an evidentiary hearing on October 7th, at which 3 CFTC commissioners, including Chairman Heath Tarbert and the Director of the Division of Enforcement, were supposed to attend. Wow. It appears we may soon gain insight into the CFTC's defense to defendants' allegations regarding the Commission's purported breach of the mutual gag order contained in the settlement order. This is how it should be. Pleadings regarding alleged wrongful actions or inactions of government agencies should not be shielded from sunlight absent compelling reason. Well, that's it for this week's edition of Bridging the Week. As always, there's more articles and more information in each article in the article version of Bridging the Week on the website. Check it out. That's www.bridgingtheweek.com. I'm Gary DeWaal. Have a nice week, and until the next edition of Bridging the Week, ciao.